from Boston. Nice to see you all this morning, looking so awake and eager and ready for the day, right? Right. NCDC, right? So we have this really awesome tradition here, which is that I have the pleasure and the privilege of introducing your first speaker. Roan is the training director for the Colorado State Public Defender System. And she's a career public defender, career criminal defense lawyer, and has been a public defender since 1989. She worked in the trial units there, trial offices, 3 of them, for over 10 years. And then she spent 6 years in their appeals units and doing death penalty work, as well as the other kinds of cases that we do as public defenders, and doing it at an extremely high level. And that experience of the trial experience and the appellate experience let her bosses know that they'd be idiots not to make her the statewide training director when she got that role. One of the things that I love most about Roan is that she is an absolute warrior for her clients and an absolute warrior for us. And she is here to talk with you now about theory of the case, which is, without a doubt, the single most important thing that you will hear about during the 2 weeks. And they trusted Ann to do it.
Well, good morning. Good morning. I might say good morning again. I like that better. Good morning. Okay. Theory of the case. What are we going to do about that? You have a little handout. That's an article about this idea of the positive case for innocence, and that's what we're going to be talking about this morning. And you can read it at your leisure. But the thing to think about is that the criminal justice defense system, what we have this anchored around is this quartet of fundamental constitutional rights, right? And there's the right to remain silent, and the right to counsel, and the right to be presumed innocent. But what's that 4th one that we love so much?
Right to a defense?
What?
The right to a defense?
Super awkward when you don't say the right answer. But nicely tried. No, it's the right. It's the right to make them prove it, right? We love that. Yeah, you can prove it beyond a reasonable doubt. We like it so much we make stickers about it. We like it so much that we talk about it all the time. And we think that, we can get up in front of a jury and say, ladies and gentlemen, at the end of this case, you're going to be convinced that the state has failed to prove the charges beyond a reasonable doubt. How many people have given that opening? I have. Yeah, we kind of say that stuff all the time. And so, here's the problem with it though, right? Do you guys know who this gentleman is? He's very famous in the great state of Colorado. His name is Gary Brooks Faulkner. And according to the New York Times, back when we were all looking for Osama, he just went over there by his own self. And he came armed with night vision. You remember, right? What's your name?
Ross. I do remember.
Yeah, and he had night vision goggles and a machete and like some Slim Jims? I don't know. He had some stuff, and he was just going to go kick some Osama bin Laden ass. How'd that work out for him, ma'am? Poorly.
Well.
Yeah, poorly. It was like a check minus performance on killing a terrorist. So, and that's the problem, is that he didn't have enough game. And so that's what we've got to talk about. Do I need a microphone?
Yeah.
I do.
No.
Yes, I
Is that better?
No.
Oh, it's much better. Now it's kind of feedbacky.
wrong sound.
It is the wrong sound. I know. What do you guys think? Yeah, it seems. I think I was great, right? I feel like I was.
My game without this. Okay, so we're all done with that. Where was I? So, he didn't have game and he didn't have the proper tools. And right now as we sit here in this room, neither do a lot of us, okay? And it's because we had to go to law school, all right? And so what's the first step when you have a problem? What's the first thing that you do? You admit it, right? And no judgment attaches here. But we all went to law school, and so we got something going on that's a problem for us when we're thinking about theory of innocence. And that problem is what do you read in law school to help you learn the law? Rhymes with appellate. Appellate? Yeah, you got it. Okay. You read appellate decisions, okay? And so, for example, and what they are these really sterile and truncated versions of facts that you don't pay much attention to. And what you do is you divide the rule of law out of it, and then you apply it to other similarly sterile and truncated versions of facts that your professors come up with for the test. So if you want to look at this, here's Plessy versus Ferguson. Have you guys heard about that case? Just checking. Pretty boring, right? I don't even, I don't know, there's some fractions in there. 7/8 Caucasian, 1/8 African, blah, blah, blah. But that's the whole statement of facts in Plessy. And it doesn't tell you that there was this guy named Homer Plessy who was born on St. Patrick's Day, 1862, just 3 months after Abraham Lincoln signed the Emancipation Proclamation. And when he grew up in New Orleans, it was still under federal control, and so there really wasn't segregation. But when the Civil War ended and the federal troops withdrew, things got tighter and tighter and tighter on the black population. And so by the time Mr. Plessy, was in his 30s, black people couldn't ride in the same train cars as white people. And Mr. Plessy was a shoemaker. That's what he did for a living, is he made shoes. And there was this thing going on in New Orleans. You know how they always have to talk French in New Orleans because they think they're so great? So it was called the Comité des Citoyens, the Citizens Committee. And it was a bunch of people, it was a bunch of mixed blood and Creole and African Americans who were fighting for equal rights for all people. And they picked out Mr. Plessy because he was 7/8 white and 1/8 African. And so what they said about him is that he looks like he can get on the train, but he'll also get arrested for doing so, and that's why we need Homer Plessy. And so they sent him to get on that train, and they got him arrested, and that's what started this decision. But that's the real story behind Plessy versus Ferguson. That's the story of innocence. That's the positive analysis of what the defense has in that case and what the state doesn't have. But when we read things in law school, we miss all that. Did anyone know this about Homer Plessy? No! Isn't that a better story than this bullshit? Yes! Okay. So those are the stories that we want to tell. And when you look at your cases, and when you look at your cases in brainstorming today, if you look at them with an eye toward what the state doesn't have, what they can't prove beyond a reasonable doubt, you're doing what I call negative case analysis. You're looking at what is not there for the state rather than what is there for your innocent client. And there are a lot of bad things that flow from a negative case analysis. You get into all this strange language because you're talking about what the state can't prove beyond a reasonable doubt, okay? And that's kind of abstract language, and it's conclusory language, and it's not persuasive language. And you miss what is persuasive in your facts. You know, you miss what you could tell about Homer Plessy. And you also get into weird client communication because you're sitting, let's say Tommy Smith, Great State of Alaska. Have you guys met Tommy yet? He's fantastic. He can skin a bear. I don't know if that's true. It probably is though. So Mr. Smith's my client, and then I'll say, well, see, the thing is, Mr. Smith, they can't prove beyond a reasonable doubt that you intended to commit the crime, so that's going to be our whole defense. And Tommy's thinking, well, I didn't do it. That's kind of how I look at this whole thing. And so you have strange client communication. You also obviously have strange jury communication if what you're talking about is what they can't show beyond a reasonable doubt. How about this one, with self-defense as an affirmative defense? Tell me how persuasive this is. Ladies and gentlemen, at the end of this case, you are going to know that the state cannot prove beyond a reasonable doubt that Mr. Smith was not acting in self-defense, and therefore, game over. No, right? Just crazy, stupid. So what else happens is that you lose. Okay? And no one likes losing. Losing is not as good as winning. So I feel, based on my experience. So here's what happens when you stand up and give the whole, at the end of this case, you're going to be convinced that Mr. Smith, the state has not proved beyond a reasonable doubt that Mr. Smith did not act in self-defense. Here's what the jury hears, okay? And you know, if the jury hears this, they are going to act accordingly, okay? And then your little Tommy Smith isn't going to be skinning any more bears. He's just going to be making license plates. So we don't want that to happen. So to get out of that, what's the answer? Well, I'm happy to tell you. You have to normalize your client's behavior. And that's really what a theory of innocence is all about. Think about how a good prosecutor prepares a case. He takes what your client did, and he takes your client, and he makes your client the outlier, the weirdo, the guy who needs to be voted off the island. For those of you who are younger than me, which is like everyone, long ago in the early days of reality TV, there was a show called Survivor. And at the end of that show, every week they voted somebody off the island because that person was just too strange. Well, that's what the prosecutor wants to do with your client. He wants to tell the jury, look, here's somebody who has broken the rules of our tribe, okay? And we can't have him in our community anymore. And so you are going to judge him guilty, judge him not one of us, and we're going to take him off the island. So what we have to do is combat that by making the jury understand that if they were in Mr. Smith's position, they would have done the exact same thing. Because juries will acquit if they believe that they would have done the same thing your client did if faced with those circumstances. They just will. That's just how things go. So you got to figure out a way to normalize behavior. Now, I fully concede that some behavior is easier to normalize than others, okay? It's hard to normalize making a bunch of meth in a bathtub while your baby is in said bathtub. That's tougher, okay? Some cells are harder than others. But in general, if you start looking at your cases to say, what about my client's actions reverberate and resonate with things that all of us believe, you will be on track to getting a theory of innocence. And I call it a theory of innocence, not a theory of defense. Because all of your clients are innocent. I promise you this, okay? And that's a really hugely important thing for you guys to internalize. And it's easy to be cynical about that, right? But what you have to understand is that there's just different kinds of innocence, okay? There's the full-on innocence, it never happened. But there's also a happened, but I didn't do it. Alternative suspect or mistaken identification. It happened, I did it, but it's not a crime. Something like self-defense. It happened, I did it, but it's not the charged crime. The ever-popular, lesser, but still fully innocent of a charged crime. It happened, I did it, it was a charged crime, but I'm not responsible. These are defenses like entrapment and duress, mental status defenses, choice of evils. And then here's the last one. It happened, I did it, it was a charged crime, I'm responsible, so what? My friends from the great state of Kentucky, when they talk about this crime, they say, he just needed him a killing. Now, here's the thing, which is sometimes true. Here's the thing, NCDC, we're all here because we like to fight the man, right? Yeah, we're little man fighters. So here's what we do, right? And God bless us, right? Here's what we do, is we always think that's our defense. Yeah, I had a pound of meth in the bathtub, so the fuck what? And maybe that's true, maybe that's gonna be your move, but I would encourage you to make this your last move, okay? Really, 1 through 5, I put those first for a good reason, okay? But if this is your move, then that's gonna be your defense, okay? But everybody is still innocent, and you really have to start out with that premise, because if you don't believe in your client's innocence, how the heck is a jury, right? You've got to believe what you're talking about. So, there are in this life facts beyond change. Some people call them bad facts, because why? Because they're bad, yeah. So you got to think about your facts beyond change, and then your theory of innocence has to account for them. If you have a theory of innocence that does not deal with all of your bad facts, you know what you're giving the jury? Chocolate donut topped with fetal mice. Okay? No one wants to eat that, right? That's just gross. I didn't make this stuff up. But look, see,
Nasty.
it is nasty. Thank you. Who said nasty? That is what a bad defense looks like. Because see, you like, here's all the good stuff. Delicious. Lay's goodness. Oh, the chocolatey nature. And then, what is this crunching? Could it be wee fetal mice? Yeah, it could. Because here's what happens. If you only think about your good facts and you don't want to talk about the bad facts, at some point in time they're going to find those fetal mice. And then who cries? The little baby Jesus, right? And we want to comport our cases in such a way that the little baby Jesus never cries. Colorado people, you know what I'm talking about, right? Sometimes little baby Jesus cries when we fuck up, and we don't want to have that going on, because that baby is somebody got to shake that baby. So anyway, so what you have to do is you have to get a theory of innocence together, and it has to deal with all of your crummy facts, and then you have to actually write it out. Okay, I think, and it should just look like, it's just like a paragraph or two. It just is the narrative of innocence, Mr. Smith, they have the wrong man, and his fingerprints were on the gun because he was at a gun show and he handled the gun. You do whatever you need to do with your bad facts, but you really do have to write it all down. A lot of us make the mistake of thinking, I got my theory of innocence and it's just all right up here. No, it's not. You're just lying. It's not right up there. You got to write it down, and I would really encourage you guys at the end of your brainstorming today, or like when you go back to the palatial hotel tonight, that you write it down. Because in real life, when you go back to your offices, you need it, and your investigator needs it. Okay, there's no way to really start sitting down with your investigator and saying, here's what we need to do, unless they can look at what you think your theory of innocence is, because the investigation is going to help to shape the facts into a pattern that is congruent with your theory of innocence. Co-counsel definitely needs it, so you guys are on the same page, and your client needs it, okay? If you're going to sit down with your client and have a discussion about should you testify or should you not, how can you really have a meaningful discussion about that if your client doesn't understand that here's what the theory of innocence is, here's what your proposed testimony is, let's see if it adds to the theory of innocence, if it detracts, if it contradicts, and let's make a decision on whether you should testify based on that. It's a lot more collaborative and respectful conversation than just saying, Tommy, you've got 7 felonies, about 5 of them are for, letting the terrorists win and poor personal hygiene and hitting little kids, and no one believes you, and you get all angry when everyone asks you a question, and you just kind of look like a scary person. That's a terrible way to talk to your client about whether or not he or she should testify. Talking to them about, look, here's what we're doing, here's how your testimony adds or detracts, is collaborative and respectful and client-centered. So that's another reason why you got to write this out. And you need it, of course. So how do you do this? Here's what I think is a good thing to do. When you pick up a case, when you picked up your fact patterns for NCDC, I hope that you started thinking about what is my dream closing argument. Like if I had to give a closing right now, how would it sound? And if you can do that, that lets you know how you want to deal with the facts in your case, so that at the end of the case, at the end of your investigation, at the end of your cross-examination, you have what you need to give that dream closing argument, okay? You should think about what is the most persuasive story of innocence I can give, and then that helps you inform what your theory of innocence is gonna look like. But you gotta figure it out early. You gotta figure it out before you start writing motions. You gotta figure it out before you send your investigator off to talk to people. And you've always gotta be deciding everything in your case. If you can't tell yourself, I'm doing this because it in some way moves my theory of innocence forward, then you should reconsider whether or not you really wanna do it. Whether it's filing a motion, whether it's negotiating, whether it's investigating, anything like that. So your theory of innocence has to do 4 things in order for it to do what it needs to do. It has to deal with your bad facts by either neutralizing them or flipping them, okay? Let's take a lady who chopped her husband 43 times with an axe, okay? What's a bad fact in that case? She got caught, yes, that was one bad fact. Anybody have a thought about a bad fact? 43 times, that's a lot. Chopping, that's like a whole forest, right? Well, but I can neutralize that fact if I say she acted reasonably in self-defense. I can even flip that fact if I say his abuse and threat was so great that that was the number that she needed to use in order to escape that threat. But that's flipping or neutralizing. Either it doesn't matter anymore, or like, you know, if it's mistaken ID, then a lot of the bad facts don't matter because your guy didn't do it, okay? But you have to flip or neutralize all of your bad facts, every last one of them, or else there's still going to be a little mouse left on that donut, okay? And even one mouse, it turns out, is too many. It has to be internally consistent. You can't, you know, yeah, they say you got to ride one horse in this life, and sometimes in some cases you feel like what you're really riding is one sparkle-colored unicorn, but you got to stay on that animal, whatever it may be. And it has to define what the crucial contested facts are for the jury. Your decision about what your theory of innocence is going to determine what matters and what doesn't, right? Anybody ever tried a DUI case as a lawyer, not a defendant? Okay, there we go. All right, what's your name, sir?
John Gill.
Are you from Laredo, Texas?
That's right.
I like it. I like it. I was trying to remember the words to Streets of Laredo this morning, but I could not. So we'll talk about
I
that
can
later.
sing a little song for you.
Later on you will, sir. Later in the cave, you will. Okay, so, but in a DUI, if your defense is he wasn't driving, then you really kind of don't care about the BAC, right? Okay, so that's an example of defining the crucial contested facts. You got to figure out what matters for the jury and what doesn't. It's important because by doing that, you're doing the 4th thing that a theory of innocence has to do, which is give the jury a lens. The jury's very nervous. They're sitting there, they don't know what to expect, they feel like they're being bombarded with data, right? And you give them a lens so that they can figure out what matters and what doesn't in the presentation that they're about to hear. And if you can be the one to stand up and say, look, right out of the box, I'm going to tell you, 4 things are important about this case. And you're going to understand that all 4 of these things mean that Mr. Downs is innocent of these crimes. You calm the jury down, you calm their anxieties down, and you set yourself up as the person in the courtroom that is going to help them wend through this forest of nonsense to get to the happy land of innocence, okay? So, that's what it has to do. And until these things happen, you're not done. If you have some bad facts left, if there's still some mice on that donut, you got to keep working. If you hear yourself saying when you're writing out your theory of innocence, if you write something like, he didn't do it, and even if he did, okay, well, see, now you got a bunch of horses going on there. You got to put some of them down because we can only have one. Or if you look at the shiny, shiny toy. I don't want to talk about the crucial contested facts, but my shoes are fantastic. Now, see, that's not going to help you. You've got to deal only with your crucial contested facts. How about this one? Some people like to do these oh, I'm just going to lay in the weeds. And so my opening is going to kind of, you know what? back when I was a single gal, I actually had gentlemen callers tell me this on dates, and I would sit back and pay attention, and it never did make sense. I was like, what the hell just happened? So, that's not funny, right? So you can't do that, okay? You've got to be clear with the jury early on about what matters and what doesn't, and why your client is innocent, okay? And then I want to talk a little bit, this crucial contested fact issue. I think that we have to be careful about what we're willing to concede and what we're not willing to concede. I think a lot of us, myself included, get beguiled by the idea that if we narrow down the seam of contested facts to just this discrete little line, it somehow enhances our credibility. Do you know what I'm saying? I think all of us kind of do that, And so it's like, well, we all agree except for this one thing, like, who was it that killed that husband? I don't know about that. I think that sometimes that's a good move, but I think that sometimes we're just being tools when we do that, and nobody wants to be a tool in this life. Because here's the thing, you got to think about the psychology of jury deliberations and just persuasion psychology. If the jury gets back in the jury room and they say, well, the defense and the prosecution agree on this part, and they agree on this part, and they agree on this part, and really the only thing they're fighting about is this one little thing, who do you think is going to win that fight? Probably the prosecution, right? They're going to be like, well, what the heck, we'll just, the DA is right about everything else, and the defense lawyer agrees, so let's just make him right about everything. So sometimes it's just more helpful to be a little bit more ballsy and just deny everything. Just contest it all. It's tougher for the jury if you disagree about everything. No, it wasn't him. No, those aren't good fingerprints. I am going to dispute the BAC. I'm just going to go nuts, okay? And so you want to think about that because it makes it harder for the jury to find common ground if everything is a ball in play. So I just encourage you, and that's something that you just have to figure out case to case. There's no hard and fast rule about that. But I encourage you, if you find yourself thinking that you're going to agree with a bunch of stuff, just to gut check on that and make sure that you're doing the right thing for your client and for your case. So that's the theory of innocence. But then there's this idea of themes, okay? And those are two distinctive things. Here, 3 very smart men define themes, and so let's look at those. Steve Wrench, he was the first training director for the Colorado State Public Defender 41 years ago. He said that themes are emotions and ideas repeated throughout the trial, okay? Larry Posner, do you guys know who he is? He and Roger Dodd literally wrote the book on cross-examination. Go figure. So he says, the theme distills the essence of the theory of the case into a one-sentence refrain capable of being formed into a question on cross. Okay, Larry Posner's kind of a badass, all right? I've never been able to do that. I've never been able to ask a witness, so what you're saying is they have the wrong man. I never get a yes to that one. But it'd be great if you could, right? But that's what Larry says. And then Ernie Lewis, who's here today, he's up in the corner. Hi, Ernie. Ernie once said, a theme captures the theory so perfectly that the very uttering of the line calls to mind the more complex theory of the case. It's kind of like a theme in music, like da-da-da-da, right? Beethoven's Fifth, you guys all know what I'm talking about. Just that little snippet brings to mind the rest of the music. That's kind of what a theme is. The little thing that you're going to say brings to mind the more drawn out and delineated theory of innocence. Okay, so you've got to think about that. And I think a lot of us want to do themes that are cliches. Has anyone ever used a theme that's kind of like a cliche? It's okay to admit it. I have. Has anybody? Yeah, ma'am?
Sure.
What'd you use?
Probably.
You got to talk louder, I'm deaf.
I would imagine plenty of times buyer's remorse.
Buyer's remorse, okay. Anybody else? Did anyone get all Shakespeare? Oh, what a tangled web we weave. I did that. For a while, apparently, my entire practice was the defense of spiders, because I used that one like 6,000 billion times until I got sick of it. Anybody else? Ma'am?
How about if something doesn't fit, you must acquit?
No, because that actually, that's different. different, I think, and I'll tell you why in a minute.
Even if you're not using gloves, you're using your thing in your case.
Right, but great, because that's the right way to do it, I think. A cliche doesn't really have, I mean, it's kind of like divorced from your facts, like, hell hath no fury like a woman scorned. Boy, everyone wants to bust that out, right? But then, if it doesn't fit, you must acquit. That was actually a very case-specific theme. What was Johnny Cochran talking about? The gloves, but what more was he talking about? He uttered this line, and it called to mind the more complex theory of innocence, which was what?
That he was framed.
That he was framed, that Furman, and who was the other guy? Not Atwater. Furman, the twins of deception. Remember when Johnny Cochran said that? And it says in the book of Luke that if you cannot be believed about small things, you cannot be believed about big things. I'll move on. It was great. I love Johnny Cochran.
Flashback.
This is Johnny Cochran, big hat. No, but that's a case-specific theme. It has something to do with what actually happened in the case. And so, the reason that those work better than cliches is think about how juries deliberate, right? Steve Wrench spent, I think, like 80 hours, God bless his heart, listening to tapes of jury deliberations. And here's what he came out of it with. He told me that what happens is that juries they kind of do a rough sort into the people that want to acquit, the people that want to convict, and then it's this exchange of why questions. They're testing each other's conclusions about the case. And so they just ask each other these why questions. Why did the client confess if he didn't commit the... Well, that's a good question, right? I would like an answer. Why would a child lie about being sexually assaulted? Why would a police officer plant drugs on a person? Why didn't the client just walk away instead of using physical force? And here's the thing. The answer to this particular one is seldom somebody going to the jury instructions and saying, oh, well, he has no duty to retreat. They want something more case-specific, right? How about if she didn't intend to kill him, why did she hit him 43 times with the axe? And these are all why questions that if your theme answers them, you're on the road to acquittal. I kind of think about them, remember Wonder Woman's golden bracelets, which in addition to being super snappy accessories, what did they do? They repel bullets, thank you. I had somebody once say they made her plane invisible, and that man did not pass. They repel bullets. Well, a good theme is kind of like that. You get all these why questions from the haters. If your juries can give your theme as an answer to bounce those bullets away, you're on the road to not guilty. So my definition of a theme is that it gives jurors who want to acquit, and there will be plenty because you've picked your jury the correct way, case-specific, easy to remember answers to the why questions from jurors who want to convict. And that's a good theme, okay? Now, it's harder than it looks because you've got to make it very concise. A theme can't take 75 words to say. You've got to snap that baby right out. So, let's go back to more unjustified husband killing, a thing I think about a lot. My husband's here today, and now he's nervous. So, she didn't intend to kill him. The haters will ask, why did she hit him 43 times with an axe? Well, if I have the cliche theme, because hell hath no fury like a woman scorned, that's not a very good answer, is it? That just sounds kind of like crap. But how about, because the only thing Mary knew is that he was going to stop beating when she stopped breathing. Dang, where's Mary going? She's going home to wash that axe. That makes your shoulder ache after about 37. So, anyway, so that's why the theme needs to be case specific, okay? And so in your brainstorming today, you're going to be thinking about your theory of innocence, but then you need to think about the themes that are going to sharpen and brighten that theory into something portable that jurors can take into the jury room and hack through those why questions from the jurors who want to convict and get the correct verdict out of the courtroom for your innocent client, okay? So persuasive themes have to reflect values and principles that the juries share. So you can't say, well, you know, the thing about giving your baby meth is that baby stays real skinny. Because most jurors don't share those principles, right? They have to support a defense verdict as the morally correct result. And, you know, I think that sometimes we get really nervous about even saying innocence or morals or justice. It's kind of like the DA took all that vocabulary away from us. Screw that. You guys, take those words back. We have the most intensely moral job in the criminal justice system, okay? We're the ones who stand between the individual and the crushing power of the government. We should be talking about morality and fairness and justice and the right thing to do all of the time, because that's what we do for a living, okay? We have to problem solve for the jury, and we have to give labels and summaries to make complex things more understandable, okay? And that's what a persuasive theme does. You know, going back to the husband killer, she's not an axe-wielding murderer. She is a woman who has been beaten over and over and over, okay? And so you're just labeling things in a way that support your theory of innocence. And it also makes your theory of innocence plausible for the jury. So you can use your theory of innocence in all parts of a trial, and I'd like to run through quickly how that would work. If you come up with your theory of innocence and your theme early in the game, which you really have to, when you sit down to write your pretrial motions, you can decide to fact load those motions to start fleshing out your theory of innocence. You can ask the right questions in your motions hearing because you know where you're going. I mean, who has ever had the experience where you're sitting down to prepare for trial and you look at the transcript of your motion to suppress and you're like, damn it, why didn't I ask that stuff? You know, now that I know I really need this. Well, if you figure it out early in the game, your motions hearing can be part of the whole presentation. You can make sure you call the right witnesses, and you can begin to persuade before the jury ever gets in the courtroom. You know, you can tell the judge exactly what your case is about. That's going to have an effect on how rulings, evidentiary rulings during trial go. If you can start persuading your judge that this is really what this case is about, his determination of what is relevant and what is not is going to be different than if you filed a bunch of form motions that didn't talk about your case and he's kind of in the dark about the whole thing. In voir dire, we only select juries based on our theory of innocence, not on anything else, not on their shoe size or hairstyles or bumper stickers or favorite foods or, you know, what they watch on TV. And so that we understand that the juror who can't follow and effectuate our theory of innocence is constitutionally impaired, and we just get those people off for cause, okay? And so that's how the theory of innocence works in voir dire. In opening statement, it reassures the jury that we know the case and we know what we're doing. We're not just saying, oh, I'm just going to tie this all together at the end. Just stay still. Close your eyes. And so you use your theme as a refrain, a transition from one subject to the next, and as a bookend for the really important pieces of information. You know, you say over and over, and Mary knew that he would stop beating when she stopped breathing. And you keep using that as the way to move from piece to piece of information so that the theme becomes a very cohesive part of what you're talking about. And you're teaching the jury how to get the right verdict out of deliberations and back into the courtroom. In cross-examination, you've figured out your crucial contested facts, so of course those are going to be your chapters across, right? And you're normalizing your client's behavior because your cross is developing your theme and your theory of innocence. And you order your chapters in the same structure that you've imposed on your written out theory of innocence, okay? In the defense case, if you're going to put on witnesses, your client, we've already talked about that, understands whether he should testify because it's a theory of innocence-driven decision. And your witnesses understand your theory and theme. I'm not suggesting that it would be kind of looking crazy if somebody said, well, I always just felt like Mary knew he would stop beating when she stopped breathing. Okay, no one's going to believe that's an actual answer, but I think that if you explain to your defense witnesses, look, here's where we're going with this case, here's how your testimony fits in, they're going to be able to contextualize the questions that you ask them and give more cogent answers. There are, of course, exceptions to this. If you have to call a cop to prove something up that the DA didn't deal with in their case, or you need to cross the cop on something, I wouldn't hand that cop my theory of innocence and just say, hey, officer, just, FYI, here's where I'm going here. So, use some judgment. And then in jury instructions, which you should be writing out very early, you have more insight into the elemental instructions and what changes you may want to make and how the law actually works with respect to your case. Same with affirmative defenses and verdict forms. And if you're in a jurisdiction that lets you write a theory of the case instruction, well, you can write a really good one because you know exactly what you're saying. And then, of course, in closing, it's the same thing. It's a bookend and a refrain and a transitional device, but your theory of innocence stays the same. And so the jury has that nice, satisfying feeling of the narrative arc of the beginning, the middle, the end. You made the promise, you fulfilled the promise, and now you're keeping the promise in the closing. So you are the person that has the coherent and cohesive narrative. You're the most persuasive person in the courtroom. And it also helps you figure out what demonstrative aids you want. Maybe you're not afraid of that axe anymore. Maybe you really want to drag that in because that was how bad things got that she had to resort to this, right? A little kitchen knife, manicure scissors, tweezers, that wasn't enough to stop him. She needed an axe. So here's the thing. I think that it's easy to get cynical about what we do. And I think that a lot of older lawyers, especially, are all like, oh, my guy's so guilty, but yeah, you know what I mean? Don't be that lawyer, you guys. Really don't be that lawyer. Be brave enough to forego cynicism. Be brave enough to say, I have an innocent client, and I'm going to fight for that innocent client, and here's the kind of innocence that he is. Because if you get cynical, if you fall into the trap of slightly marginalizing your clients because even you think that they did it and that they somehow deserve to be voted off the island, the jury will pick that up, and even more terribly, you'll start to pick that up. The best criminal defense lawyers, especially the best public defenders, are people that stay there year after year and don't get burnt out and stay vital, because then you have all of your experience that you can bring to bear for people who have always had second best of everything, and all of a sudden they get this just Cadillac of a lawyer, this Heineken of a lawyer, this Prada shoes of a lawyer, right? And that's a good thing, because your clients do really need you. And our country needs you a lot right now. Things are weird in our country, right? And the poor are kind of fodder, right? And if we don't have people who honestly believe they are fighting for justice and innocent people, then who's crying?
Baby Jesus.
Little baby Jesus. And we would just like that guy to be quiet. So I want to tell you about one more case before we go into our brainstorming rooms. And that case is called Boynton versus Virginia. And you can find it at 364 U.S. 454. And let me tell you a little bit about Boynton. Boynton got decided in 1960, and Boynton stands for the proposition that it is unconstitutional in interstate travel for states to segregate at bus stops. In other words, if I'm riding a bus from state A to state B, there can't be one waiting room for white people and one waiting room for black people, okay? And that was in 1960. The southern U.S. decided that Boynton was sort of like a guideline rather than an actual law, and so they didn't comply with it. And so in 1961, 50 years ago, okay, not that long ago at all, 13 people decided to get on Trailways buses and Greyhound buses. And the plan was that they were all going to ride from Washington, D.C. to New Orleans, which meant that they would have to go through Alabama, Georgia, and Mississippi before they got to Louisiana. And they picked 13 of them. This was led by James Farm, who was running the Congress on Racial Equality, okay? And he recruited young students, for the most part, to do this, and he got 7 African Americans and 6 Anglo Americans to be freedom riders with him. And one of the men, the young man that went on this ride, was a guy named John Lewis, and he's now a congressman from Georgia in the House of Representatives. But at that time, John Lewis was 21 years old, and he grew up, his parents were sharecroppers in Alabama, in a city called Troy. And all his parents wanted was for him to get an education and get the hell out of Troy, Alabama, and have some opportunity in his life, and he did. And he went to Nashville, and he was at the Baptist seminary there. But then the Freedom Rides came up, and he applied to be a Freedom Rider, and he wrote in his application, I'm going to have to quit school to do this. I'm going to miss finals, and I'm going to flunk out because I won't take my finals. And it's going to kill my mom and dad. But I've decided that human dignity is more important to me than finishing my education right now. And you know, those 13 people got on the bus in Washington, D.C., and at first everything was great. They were singing little songs and having fun. But you know, when they got to Alabama, people were waiting for them, and they set those buses on fire while people were riding those buses. It was horrible. When they went to Mississippi, they all got thrown into Parchman Prison. And they were doing this because they wanted to know if the U.S. Supreme Court was serious about that promise that segregation was going to stop. They wanted to know if the U.S. Supreme Court was going to keep the promise that it made when it published Boynton. And Bobby Kennedy got involved eventually because the whole South was blowing up because of these 13 people. And he went to James Farmer and he said, you know what, Mr. Farmer, you've proved your point. Don't go on to New Orleans, though. Why don't you just wait and let's have a cooling off period? And you know what James Farmer said? He said, Mr. Kennedy, black people in this country have been cooling off for 350 years. We cool off one day longer, we're going to end up in a deep freeze. No, we are going on to New Orleans. And what I suggest to you is that you are here in your careers and in these 2 weeks to figure out if the United States is going to keep another promise that it made. The promise that it made in Gideon. The promise that people like you, good, talented defense lawyers, are necessities, not luxuries. And that's what those bracelets say, and I hope that you'll hang on to those for these 2 weeks. Because that's the promise that everybody, no matter who you are, where you were born, what color you are, how much money you have, what you're charged with, everybody deserves a lawyer who thinks that person is innocent and who is going to fight for that innocence and who is going to give the best defense regardless of money, regardless of anything, and that is a necessity, not a luxury. We're here to help you. But when you leave here, you are here to get up every morning and go into court and ask this country, are you going to keep Gideon's promise? I beg you not to take no for an answer. Thank you.